Administrative law. Evolution of administrative law, definition and its scope. Evolution of administrative law. Administrative law is the most outstanding legal development, arising from confrontation with the complex problems of socio-economic justice in the welfare state. In India itself, administrative law can be traced to the well-organized and centralized administration under the Mauryas and Guptas, several centuries before the Christ, following through the administrative system of the Mughals, to the administration under the East India Company, the precursor of the modern administrative system. The rapid growth of administrative in modern times is the direct result of the growth of administrative powers and functions. Definition. Administrative law is the law relating to the administrative operation of government. It deals with powers and duties of administrative authorities. The procedure followed them in exercising the powers and discharging the duties, and the remedies available to an aggrieved person when his rights are affected by any administrative action. According to Robson, administrative law should be regarded as the law relating to public administration, in the same way as commercial law consists of the law relating to commerce, or land law the law relating to land. Scope. Administrative law is concerned with the operation and control of administration, with emphasis on function rather than on structure. Pervasive legal discipline. Law in realist sense. Meaning of administration. Administrative process. Expanding horizons of administrative jurisdiction. Measures of administrative law. Rule of law. Meaning. The term rule of law means the principles of legality, which refers to a government based on principles of law, and not of man. According to Dicey, rule of law is one of the cardinal principles of the English legal system. He attributed the following three meanings to the doctrine: supremacy of law, equality before law, and predominance of legal spirit. Rule of law under the Indian law. Rule of law permeates the entire fabric of the Indian Constitution, and indeed forms one of its basic features. Supremacy of the Constitution. Constitutional requirement of equality. Constitutional guarantee and judicial enforcement of rights. Rule of law as a legal concept. Rule of law as a feature of basic structure. Separation of powers. Meaning. There are generally three categories of government powers: the legislative, the executive, the judicial. At the same time, there are three organs of the government in a state: the legislative, the executive, the judiciary. The theory of separation of powers postulates that these three powers of the government must, in a free democracy, always be kept separate, and be exercised by separate organs of the government. Historical background. The doctrine of separation of powers is of ancient origin. The history of the origin of doctrine is traceable to Aristotle. In the 16th and 17th centuries, French philosopher John Bodin and British politician Locke respectively had expounded the doctrine of separation of powers. But it was Montesquieu who for the first time gave it a systematic and scientific formulation. Montesquieu S Theory. According to this theory, powers are of three kinds: legislative, executive, and judicial, and that each of these powers should be vested in a separate and distinct organ. For it all these powers, or any two of them, are united in the same organ, or individual, these can be no liberty. Doctrine of separation of powers in practice, India. Constitutional conspectus. Parliamentary executive. Broad division of functions. Functional overlapping. Constitutional recognition. Basic feature. Indira Nehru Gandhi v Raj Narayan. M. H. Begg has observed that separation of powers is a feature of basic structure of the Constitution. Delegated legislation. Necessity of delegated legislation. Delegated legislation is not an isolated phenomenon. Following factors are responsible for the rapid growth of delegated legislation at large scale. Pressure upon parliamentary time. Technicality. Flexibility. Experimentation. Emergency. Confidential matter. Complexity of modern administration. Classification of delegated legislation. Title-based classification. Nature-based classification. Normal delegation. Positive. Negative. Exceptional delegation. Constitutionality of delegated legislation. Pre-Constitution period. Post-Constitution period. Constitutionality of delegated legislation. Section 7 of Delhi Laws Act, 1912. Section 2 of Ajmer Muir, Extension of Laws, Act, 1947. Section 2 of the Part C States, Laws, Act, 1950. Principles laid down in the reference case. Parliament cannot abdicate, or efface itself, by creating parallel legislative body. Power of delegation is ancillary to the power of legislation. The limitation upon delegation of legislative power is that the legislature cannot part with its essential legislative power that has been expressly vested in it by the Constitution. Essential legislative power means laying down policy of law and enacting that policy into a binding rule of conduct. Control over delegated legislation. Due to the complexities and exigencies of intensive form of government, the institution of delegated legislation has come to stay. In almost all the countries, the technique of delegated legislation is used at a large scale, and some legislative powers are delegated by the legislature to the executive. The controls, which are exercised over delegated legislation, may be divided into three categories: judicial control, legislative control, procedural control, judicial delegated control. In the control mechanism, judicial control has emerged as the most outstanding controlling measure. Judicial control over delegated legislation is exercised by applying two tests: substantive ultra vires and procedural ultra vires. Ultra vires means beyond powers. Where parent act is ultra vires the Constitution. Express constitutional limits. Implied constitutional limits. Constitutional rights. Constitutional rights. Where delegated legislation is ultra vires the Constitution. General. Arbitrary power is ultra vires the Constitution. Theory of derivative immunity. Where delegated legislation is ultra vires the parent act. Delegated legislation is excess of the power conferred by the parent act. Delegated legislation in conflict with the parent act. Parliamentary control. A three-pronged control is exercised by the legislature over delegated legislation as follows: proceedings in Parliament, laying on the table and scrutiny committee. Procedural control. Procedural control mechanism has the potential to meet the aforesaid requirements. There is now emphasis on procedural control. It has three components: antecedent publicity, publication, consultation of interests. Principles of natural justice. Natural justice is envisaged, in administrative law, for ensuring fair exercise of power, by administrative agencies. Nemo judex in sua causa, rule against bias. General. No one should be a judge in his own cause, and justice should not only be done but seen to be done. Type of bias. Pecuniary bias. Personal bias. Subject matter bias. Audi alteram partem, rule of hearing. General. The Audi alteram partem rule means that no one should be condemned unheard. Ingredients. Notice. Adequacy of notice. Reasonable opportunity. Hearing. Oral hearing. Fair hearing. Cross-examination. Legal representation. Right to new evidence. Opportunity of being heard. Reasoned decision. Meaning. A reasoned decision means as decision, which must contain reasons in support of it. India. Implied statutory requirement. Reasons by appellate authorities. Disclosure of reasons. Doctrine of legitimate expectation. Writs with special reference to. Prerogative remedies, are provided through writs. Provisions for prerogative writs have been made, under Articles 32 and 226 of the Constitution of India. Writ of habeas corpus. General. The writ of habeas corpus is a process by which, an individual who has been deprived of his personal liberty, by any executive act. Writ of prohibition. Writ of certiorari. General. Certiorari is a Latin word which means to certify. Certiorari may be defined as a judicial order, issued by the Supreme Court, under Article 32, or by a High Court under Article 226 of the Constitution, to an interior court, or any authority, exercising judicial, quasi-judicial, or administrative functions, to transmit to the court, the records of proceedings pending therein for scrutiny, and decide the legality, and validity of the orders passed by them. Writ of Mandamus. Nature and scope. Mandamus is a command, which is issued by a court, to an authority asking it to perform a public duty, imposed upon it by the Constitution, or any other law. Writ of quo warranto. Meaning. Quo warranto means what is your authority. The writ of quo warranto is a judicial order against an occupier of an independent substantive public office, to show by what authority he is in such office. Conditions. Public office. Public office to substantive in nature. Holder to be occupation of office. Who may apply? Any private person. Applicant may not personally aggrieved or interested in matter. Applicant need not to complain non-performance of accused. When may refused. Issue of writ in nature of quo warranto, is a matter of discretion of court. Court may refuse in case of, when there is adequate alternate remedies. Public interest litigation. Meaning. Public interest litigation means a legal action, initiated in a court of law for the enforcement of public interest, or general interest in which the public or class of the community, have pecuniary interest of some interest, by which their legal rights or liabilities are affected. Nature and scope. Pill has been invented, as a judicial strategy in response to social activism. Jurisdiction. In India, this new class of litigation, is justified by its protagonists on the base of generality of vast areas, in our population of illiteracy and poverty. Object. Pill is a challenge, and an opportunity to make basic human rights meaningful, to the deprived and vulnerable sections of the community, and assure them, social and economic justice. Case. MC Mehta v. UOI. Court considered environment pollution problem in detail. Ombudsman, LPL, in India and Lokayukta in state of UP. Ombudsman, LPL, in India. Meaning of Ombudsman, Lotpal. Ombudsman means, the grievance man or, a commissioner of the administrator. According to, Professor S.K. Agrawal, the term ombudsman, refers only to institution, which have, those basis and unique characteristics. Ombudsman is an independent, and nonpartisan officer, of the legislature who supervises the administration. He deals with, specific complaints, from the public against administrative injustice, and maladministration. He has the power to investigate, criticize, and report back to the legislature, but not to reverse administrative action. Ombudsman in Indian, LPL. General. Generally as good administration is reasonable, and responsive to the people. With this object, in view the institution of ombudsman, came to be established in several democratic countries, for redressing the grievances of the public, against administrative faults. Jurisdiction. Any administrative action, taken by or with approval of a minister, or secretary of union, or state government. Action can be taken on request of aggrieved person or suo motu. Exclusion. Matter in which, aggrieved person has any remedy, before a court or tribunal. Foreign matters. Foreign government. Foreigners Act. Extradition. Investigation of crime. LPL Bill 2013. Background. The LPL Bill 1989. LPL Bill 1996. LPL Bill 1998. LPL Bill 2013. Important points. An act to provide for the establishment of a body of LPL for the Union and Lokayukta, for states to inquire into allegation of corruption against certain public functionaries, and for the matters connected therewith or incidental thereto. LPL means the body, established under Section 3 of LPL and Lokayukta Act 2013. Jurisdiction of LPL includes Prime Minister, Ministers, Members of Parliament, Group A, B, C and D officers and officials of center government. Lokayukta, Section 63. Every state shall establish a body to be known as the Lokayukta for the state. Lokayukta in state of UP. Necessary provision, for establishment of ombudsman system in Uttar Pradesh, have been made under, the Up-Lokayukta and Up-Lokayuktas Act 1975. Appointment and service conditions. As provided under Section 3, of the Up-Lokayukta and Up-Lokayukta Act 1975. The Lokayukta shall be, appointed by the Governor, after consultation with the Chief Justice of High Court, and Leader of the Opposition in the Legislative Assembly. Lokayukta shall be a person, who is or has been a judge of the Supreme Court or High Court. Jurisdiction. On complaint, Lokayukta may investigate any action, which is taken by, or with the general or specific approval of a minister of secretary and any specific person including public servant, notified for this purpose, by the state government. On complaint, Up-Lokayukta may investigate any action which is taken by, or with the general or specific approval of, any public servant not being a minister of secretary. Administrative tribunals, with special reference to central administrative tribunals. Introduction. Part A has been inserted in the Constitution, by the 42nd Amendment Act 1976, which confers power on Parliament and state legislature to provide for establishment of tribunals to deal with specified subjects. Constitutional basis of administrative tribunals and concerned Act as amended. Establishment of administrative tribunals. The administrative tribunals, which are to be established, under the Administrative Tribunals Act 1985, may be classified into three categories. Central Administrative Tribunal, State Administrative Tribunal and Joint Administrative Tribunal. All the three kinds of administrative tribunals are to be constituted by the central government by notification. Structure. A chairman, vice chairman, judicial members, administrative members. Qualification. Chairman, a retiring or retired Chief Justice of a High Court or a senior judge of proved ability. Vice Chairman, District Judge or Advocate qualified to be High Court Judge. Judicial Member, P.E. Person qualified to be a High Court Judge or Member of Indian Legal Service with 3 years of Grade 1 service. Administrative Member, 2 years service as Additional Secretary to Central Government, or same of higher pay. Or 3-year service as Joint Secretary to Central Government, or same of higher pay. Term of office, 5 years. Chairman 65. Vice Chairman 65. Judicial members 62. Administrative members 62.